Hello and welcome to BYJU'S IAS. Beginning today till September 26. Join us live every evening 7:30 to 9:30 p.m. and we will help you revise current affairs of the last 1 year. But first up, what should you expect from these live sessions? Number one, we are going to cover current affairs subject-wise. Polity-based current affairs, international relations-based current affairs, economics, environment and ecology, science and technology. There's a special class for various reports and indices. There is a special class for various government schemes. What else can you expect from these live sessions? Number one, we are going to provide you the PPTs that we shall be using. So you can click on the download button that is provided in the video description and you can download these PPTs that we shall be using. Also, we'll be providing you with a question bank, lots and lots of MCQs which you can revise and which you can use for last minute revision. What else can you expect from these live sessions? You might have noticed that we have disabled the live chat, primarily because we want you to focus on the smart board. We do not want you to interact with each other, but the comment section is open. As soon as we discuss the MCQs, be the first ones to type your answer and evaluate yourself before UPSC evaluates you. And at the end, these classes are not free. You will have to pay for us in the form of likes, comments, subscribe to our channel if you haven't yet, and share the links of these live classes with your friends and fellow aspirants. So let's get started. But first up, let's look at Preamble. Preamble is in the news because of anti-CAA protests. The protesters in different parts of the country, they started reciting the Preamble. So you can expect at least a question from Preamble. But what sort of questions? And this is something, let's do a quick recap. Preamble. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, equality of kind and of opportunity, liberty, fraternity, dignity of an individual. And we have given ourselves this constitution. So when we look at this preamble, we can break it to 4 parts. So there are 4 things that preamble tells us. Number one, what is the source of the constitution? We the people. People are the source of this constitution. Number 2, it tells us about the nature of the Indian state. What is the nature? Sovereign, socialist, secular, democratic, republic. It also tells us about the objectives of the constitution. And what are these objectives? Equality, liberty, fraternity, justice, dignity of an individual. And at the end, preamble also tells us the date on which the constitution of this country was adopted. And what is that date? 26th November 1949. But this constitution came into force on 26th January 1950. That is what we celebrate as the Republic Day. These are some facts related to preamble, can be asked in your examination. Also, preamble is based on the Objectives Resolution of Pandit Nehru. Again, this can be asked in your examination. This Objectives Resolution was adopted by the Constituent Assembly on 22nd Jan 1947. But please remember one thing. Although this Objectives Resolution was adopted by the Constituent Assembly on 22nd Jan 1947, but preamble was the last item added to the Constitution. This can be an important statement for your examination. The last item added to the preamble was, added to the Constitution was the preamble of the Constitution of India. Another important fact, preamble is part of the Constitution. In about 1960s, in Berubari Union case, Supreme Court said preamble is not part of the Constitution. But 1973, Keshavananda Bharati versus State of Kerala. Keshavananda Bharati died yesterday. So Keshavananda Bharati is in the news. It was in this judgment that Supreme Court said, no, preamble is part of the Constitution. Let's look at what sort of question can be asked. Please look at this carefully. What does the phrase "give to ourselves this Constitution" in the preamble signify? Type in your comments and write the answer to this question. Individually, when we look at the options, Parliament has limited powers. This statement is correct. The powers available with the Parliament, they are not unlimited. There is a limitation on the powers of the Parliament. This statement is correct. But does that mean this phrase, "give to ourselves this Constitution," means Parliament has limited powers? No. All governmental organs and institutions, they owe their origin to the Constitution. Individually, in isolation, even this statement is correct. But that is not the meaning of this phrase. The meaning of this phrase is Constituent Assembly is sovereign. So this can be a question asked in your prelims examination. Let's look at something else. Legalism. And this was the term that was used almost every day in the newspapers. Take a look at the Hindu newspaper. Take a look at the Indian Express newspaper. This term was almost every day part of the newspaper articles. What does this phrase, legalism, mean? Does this mean that laws passed by the legislature shall be in agreement with the Constitution? This statement is correct, but it is not the definition of legalism. The definition of legalism is given by Professor Keith in his book, Constitutional Law. And Professor Keith says legalism means power of the judiciary to decide legality of the laws passed by the legislature. That means one by one, if you look at all these statements are correct. Demarcation of powers between the center and the states. That's what federal constitution talks about. In a federal polity, powers are distributed between the center and the states. So in isolation, this statement is also correct. But that is not the definition of legalism. Legalism, according to Professor Keith, means power of the judiciary to decide the legality of the laws passed by the legislature, passed by the Parliament. Let's look at something else. Part 1 of the Constitution, Union and its territory. And this is in news because of Jammu and Kashmir reorganization. First things first, we have 28 states in India and we have 8 union territories in India. Effective 26th Jan 2020, 2 union territories, Daman and Diu and Dadra and Nagar Haveli, they were merged together. So as of now, till date, we have 28 states and 8 union territories. It's because of these 2 union territories that part 1 of the Constitution is in news. It is because of Jammu and Kashmir reorganization also that union and its territory is in the news. But what is it that you need to understand from this chapter? Consultative process. What is the process of reorganizing the country into various states and union territories? Let's understand the process very briefly. First, there has to be a bill. For example, Jammu and Kashmir reorganization bill. We want to reorganize Jammu and Kashmir. We want to strip Jammu and Kashmir of its statehood. And we want to convert Jammu and Kashmir into 2 union territories, Jammu and Kashmir and Ladakh. For that, what do we need first? We need a bill. This bill has to be passed by the Parliament, has to be passed by both houses of the Indian Parliament. But this bill cannot be introduced in the Parliament without the permission of the President of India. So without President's permission, this bill, reorganization bill, cannot be introduced in the Parliament. But then, President, before he gives his consent, what President has to do? President has to refer this bill to the Legislative Assembly of that state which is going to be affected by this bill. For example, 2014, Andhra Pradesh was bifurcated into Andhra Pradesh and Telangana. That Andhra Pradesh reorganization bill, first President had to give his permission that please President, please give us the permission so that we can introduce this bill in the Parliament. But President, before he gave his consent, he sent this bill to the Legislative Assembly of Andhra Pradesh, and that is the consultative process. But whatever consultation happens, whatever recommendation is given by this Legislative Assembly, that is not binding on the President. That means even if the Legislative Assembly says that we are not happy with the bifurcation, we do not want reorganization of our state, this consultation is not concurrence. This consultation is not binding on the President of India. And then when President gives his consent, this bill can be introduced in the Parliament. But where? First in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha, in either of the two houses. So this bill, which talks about reorganization of a state, it has to be passed by the Parliament. But it cannot be introduced in the Parliament without the consent of the President of India. But before President gives his consent, what President has to do? He has to consult. Consult what? The Legislative Assembly of that state which is going to be affected by this bill. But whatever recommendation is given by that Legislative Assembly, that is not binding on the President. And then President gives his consent. This bill can be introduced in either of the two houses of the Parliament, and this bill requires simple majority. And once this bill is passed, then President signs this bill becomes an act, and then the state is reorganized. So this consultative process can be asked in your prelims examination. But let's look at the question, and please type in your answer. Which of the following statement is or are correct? Jammu and Kashmir is the first Indian state to be stripped of its statehood. This statement is wrong. That is why you don't have to blindly follow the newspapers. Newspapers would tell you that Jammu and Kashmir is the first Indian state to be stripped of its statehood. This statement is incorrect. Why? Because Delhi, till 1956, was a state. You would recall that at the time of the commencement of the Constitution, we had Part A, B, C, D states. In Part C, we had Delhi and Coorg, for example. Delhi had a legislative assembly. In fact, the election was held in 1952 for the first time. Delhi, till 1956, was somewhere closer to a state. It had a legislative assembly. But when in 1956, States Reorganization Act was passed, it is that States Reorganization Act which stripped Delhi of its statehood. So J&K is not the first state, is not the first Indian state to be stripped of its statehood. No, Delhi was also stripped of its statehood in the year 1956. And second, no secession of Indian territory can take place without a constitutional amendment. And this is something that Supreme Court said in Berubari Union case, that if the Parliament wants to give up, secede a part of its territory to another country, for that they have to pass a Constitutional Amendment Act. So statement 2 is correct. Which is the correct answer? Only 2. This can be a question in your prelims examination. Now again, we are seeing clashes along the line of actual control between India and China. And for that, Sikkim is also in the news. And how? Let's look at the policy or the foreign policy of Mao, or Mao Zedong, or Mao Zedong, no matter how you pronounce his name. One of the most undisputed leader of China. He had a foreign policy, and his foreign policy was right hand, palm and 5 fingers. Palm is Tibet, 5 fingers, Ladakh, Arunachal Pradesh, Nepal, Bhutan, Sikkim. The foreign policy of Mao Zedong was that we have to liberate this right hand, the palm as well as 5 fingers. One of the 5 finger is Sikkim. So if the question asks you, is Sikkim claimed by China as its territory? No. When Sikkim was admitted into India, first as an associate state, the year was 1974. So this statement is correct. Till about 2003 or 2005, Sikkim was claimed by China as its own territory. But in 2003, again in 2005, Sikkim is not a dispute, is not a matter of dispute between China and India. So in 2003, again in 2005, China has completely given up its claim on Sikkim. So Sikkim is no longer a matter of dispute between India and China. So this statement is wrong. Which of the above statements are correct? Only one. Let's look at something else. Citizenship. Part 2 of the Constitution of India. Citizenship is in the news because of Citizenship Amendment Act. What is the Citizenship Amendment Act? First thing, CAA is basically an amendment to Indian Citizenship Act of 1956. So when we say Citizenship Amendment Act, this CAA amends what? It amends Indian Citizenship Act of 1956. What CAA tries to do? CAA tries to provide citizenship to Hindus, Christians, Sikhs, Buddhists, Jains, Parsis. 6 religious minorities from 3 Islamic countries, Pakistan, Afghanistan, and Bangladesh. They are to be provided citizenship. This is the crux of CAA of 2019. But please remember this carefully. When we say Indian government tries to give citizenship to religious minorities who are religiously persecuted in Pakistan, Afghanistan, Bangladesh, this statement itself is wrong. Why? Don't confuse yourself in the exam. If in the examination it is mentioned that the government tries to give citizenship to religiously persecuted minorities from Pakistan, Afghanistan, Bangladesh, this statement is wrong. Why? Because the Act, CAA, never talks about religious persecution. It is silent on religious persecution. But yes, whenever a bill is passed, almost in all the cases, there is statement of objects and reasons. This statement is presented to the parliament. Why exactly do we want to bring this law? It is in that statement of objects and reasons that it is mentioned that these communities are facing religious persecution. But the Act itself, it never talks about that we want to give citizenship to these 6 religious minorities because they are facing religious persecution. Religious persecution as a word is not mentioned in CAA. Please get this absolutely clear. What sort of question can be asked? Let's look at the question. Which of the following is or are features of CAA 2019? The Act provides that the central government may cancel registration of OCIs if the OCI has violated any law that is in force in the country. Is this a feature of CAA 2019? Yes. Even prior to this amendment, even prior to CAA, OCI cards could be cancelled. And there were 5 reasons on the basis of which OCI card could be cancelled. If you have committed fraud, your OCI card can be cancelled. If you are disloyal to the Constitution of India, your OCI card can be cancelled. If I got this OCI card today, but within 2 years, I have been sentenced to a jail term of 2 or more years, my OCI card can be cancelled. But a 6th ground was mentioned on the basis of which OCI card could be cancelled. This 6th ground was mentioned by CAA 2019. And what is this 6th ground? Any law if you violate. An OCI card holder, if he or she violates any law that is in force in this country, her or his OCI card can be cancelled. And this OCI card is also in the news because Tavleen Singh's son, Atish Tasir, one of the celebrated writers and journalists, his OCI card was also cancelled. That means OCI, apart from CAA, is in the news, and this statement can be asked in your prelims examination. So statement 1 is correct. Statement number 2, the Act for the first time permits illegal migrants to apply for Indian citizenship. Absolutely right. Because prior to 2019, illegal migrants were never eligible for Indian citizenship. For the first time, Indian citizenship doors were opened for illegal migrants, and that is because of CAA 2019. Statement number 3. The illegal migrants belonging to 6 religious minorities from Pakistan, Afghanistan, Bangladesh shall be provided citizenship even without any documentary proof. This statement is not correct. Why? Because the rules to implement CAA, these rules have not been passed yet. These rules have not been released yet. So we do not know whether or not documents would be required for someone to apply for Indian citizenship under CAA 2019. So this statement is incorrect. Which of the above statements are correct? A, only 1 and 2. Let's look at something else. Which of the following statements are correct? Number 1, the term domicile is defined under Part 2 of the Constitution. Domicile again in the news. Why? Because of what happened in Madhya Pradesh, what happened in Haryana, what happened in Jammu and Kashmir, for example. Jammu and Kashmir released rules, domicile rules. All those who have stayed in J&K for 15 years, they are the domiciles of Jammu and Kashmir. Those who have completed 10th standard, 12th standard from J&K, they are the domicile of Jammu and Kashmir. If you are a civil servant posted in Jammu and Kashmir, you are a domicile of J&K. And only if you are a domicile of J&K can you apply for government job. So domicile as a term is in the news, but this term domicile is not defined in the Constitution at all. So this phrase, this term domicile is not mentioned, defined in the Constitution. So first part is incorrect. Domicile can be prescribed as a qualification for government jobs. Is this statement correct? This statement is correct. So what is the correct option? B. Only 2 is the correct answer. Let's look at something else. When CAA was passed, close to 140 petitions were filed in the Supreme Court, challenging the constitutional validity of CAA. Something interesting happened, something unprecedented happened. United Nations Commissioner for Human Rights approached the Supreme Court of India and said, please treat us as amicus curiae. What is amicus curiae? Basically, friend of the court. When the court is deciding a particular matter, the court may ask somebody to assist the court. And that somebody is what we call friend of the court or amicus curiae. United Nations Commissioner for Human Rights approached the Supreme Court and said, please treat us as amicus curiae. We want to help you so that you can decide the constitutional validity of Citizenship Amendment Act. So this is in the news and you can expect a question on United Nations HCR. Let's look at few facts. It was established when a resolution was passed by United Nations General Assembly. The year was 1993. Its role is to protect and promote the effective enjoyment of human rights, but most importantly is statement number 4. Why? It supports domestic courts with their constitutional or judicial function. When the Supreme Court performs its judicial function, decides whether a law is constitutional or not, in that case, UNHRC has a role to play. It has a role, it has the power that it can assist the domestic courts in discharging their legal duties, legal functions. This statement can be asked in your prelims examination. Let's look at something else. Part 3 of the Constitution, fundamental rights. Why is it in the news? Because of various Supreme Court judgments. Number 1, when the protests broke out against CAA, many people were reminded of a statement given by Arundhati Roy. She had said in 2010 that I am a single, independent, mobile republic and I secede. Can one individual secede from the Union of India? We know for sure that states do not have the right to secede from the Union of India. Indian Union is indestructible. Union cannot be destroyed. No state has the power to secede from the Union of India. But can an individual secede from the Union of India? So this statement came to light in 2019 when there were protests against CAA. Let's look at the question. It is open to a citizen to waive any fundamental rights that are conferred by the Constitution. Can a citizen say that I don't want this fundamental right, I want to waive off this fundamental right? Is it possible? No. Something else. The judiciary presumes a law passed by the legislature is constitutional. And this is where we come across an interesting doctrine, presumption of constitutionality. Whenever a law is passed by the parliament and then this law is challenged on the Supreme Court, the Supreme Court is asked, please declare this law as unconstitutional. Judiciary assumes that this law is constitutional. It is for the petitioner to prove that the law is unconstitutional. So there is always a presumption of constitutionality. When more than 140 petitions were filed in the Supreme Court against CAA, another counter petition was filed. Dear Supreme Court, please declare CAA is constitutional. This petition was dismissed by the Supreme Court. Supreme Court said, we start with this presumption that the law passed by the parliament is constitutional. So this statement is correct. Judiciary presumes a law to be constitutional if it is passed by the legislature. The principle of equality means that every law must have universal application to all persons. You might think, what is this statement doing in this question? If this statement is asked tomorrow in your prelims examination, don't think that this is a static portion question that is asked in your examination. This in effect is a current affairs question. Why? Because when we talked about CAA, it discriminates in favor of certain religious communities. Does that mean equality is violated? No. Equality does not mean that a law should be equally applicable to all the citizens. No. Article 14 also says equal protection of the laws. That means those who are in similar situation should be treated similarly. Like should be treated alike. Unlikes cannot be treated alike. That's the whole concept of equal protection of the laws. So this statement to a naked eye seems true, but this statement is wrong. That means statement 1 and 3 is wrong. B, only 2 is the correct answer. Let's look at something else. Reservation in jobs and educational institutions for backward classes is a fundamental right guaranteed by the Constitution. Wrong. But now you will say, what about Article 16, Clause 4? I'll tell you. Statement number 2, reservation in promotions is a fundamental right applicable to SCs and STs under Article 16, 4A of the Constitution. Both these statements are wrong. None of these statements are correct. Why? Various political parties from Tamil Nadu, they approached the Supreme Court that we have this NEET examination. In NEET examination, please reserve seats for backward classes in dental and medical entrance examination. Supreme Court said reservation is not a fundamental right. That's number 1. Number 2, in Mukesh Kumar versus State of Uttarakhand. This was a landmark judgment given by the Supreme Court. What happened in this case? Uttarakhand government announces posts. But Uttarakhand government decides that we will not provide reservation in promotion to SCs and STs. Matter went to Uttarakhand High Court. Uttarakhand High Court said, no, you can't do that. You will have to give us the data so that we can satisfy ourselves whether reservation and promotion should be given to SCs or not, STs or not. Matter went on an appeal before the Supreme Court. Supreme Court said, Uttarakhand High Court is wrong. It should not have asked for the data Because reservation in promotion also is not a fundamental right. That means, is reservation a fundamental right? Supreme Court says no. Reservation is only a discretion of the state. If the state wants to give reservation, it can. If the state does not want to give reservation, nobody can force the state to give reservation in jobs or in promotions. So both these statements are incorrect. Let's look at something else. Article 17. Article 17 says untouchability is abolished and its practice in all its forms is forbidden. And to implement Article 17, we have a law, SCs and STs, Prevention from Atrocities Act. The year was 1989. What this act talks about, that if there is a non-SC or ST person, he fights with an SC or ST person, this is atrocity. And this person should be arrested and no bail should be given to this individual. Matter went to the court. Supreme Court said this SC/ST Prevention of Atrocities Act of 1989 is misused, is abused. False cases have been filed against non-SC/ST members. And what Supreme Court said? Supreme Court said no immediate arrest unless and until the police officer who is proving this and probing these allegations, he should satisfy himself that this particular complaint is genuine. Unless and until this police officer is satisfied that this complaint is genuine, only then this person can be arrested and we will also release that individual on bail. That means this 1989 law, it was very strict when it comes to atrocities. It was very strict when it comes to abolition of untouchability. And this 1989 law was diluted by the Supreme Court. Supreme Court said no immediate arrest. Supreme Court said we will also release this individual on bail. The series of protests in different parts of the country against this dilution of atrocities law. Ultimately, Parliament entered into the picture. Parliament amended this law and restored this position. And then what Supreme Court did? Supreme Court also recalled its version. Supreme Court also recalled its original verdict. Supreme Court said no. Now arrest this individual under Atrocities Act and no bail will be given. That means Supreme Court recalled this verdict which had diluted the 1989 law. So this can be a question in your examination. But one important thing, and this is something that newspapers have often missed, and I don't want you to miss this important detail. When Supreme Court said immediate arrest will also take place, bail will also not be given, in the same judgment Supreme Court said high courts have inherent power of granting bail. That means if there is a statement in your prelims examination tomorrow that under Atrocities Act, under no circumstance can the bail be given to an accused, this statement is wrong. Because Supreme Court said in this verdict, high courts have an inherent power of granting bail. But this power should be exercised by the high courts only in exceptional circumstances, only in rarest of the rare cases. But bail can be given to an accused even under Atrocities Act. This is a very significant statement, can be asked in your prelims examination. Former President Pranab Mukherjee died recently. He was also the last recipient of Bharat Ratna. So you can expect a question on Bharat Ratna. Bharat Ratna was institutionalized for the first time in 1954. Important statement. Every year, up to 3 people can be awarded with Bharat Ratna. You don't have to necessarily be a citizen. Even a non-citizen can be awarded Bharat Ratna. And Bharat Ratna is India's highest civilian award. And it is awarded to an individual who has done exceptional work. That can be asked in your prelims examination. Another interesting thing is, there is no cash reward given to the awardees of Bharat Ratna. No cash award is given. A certificate is given. That is what we call Sanad. This certificate is signed by the President of India, and a medallion is given. This is a people-shaped medallion. At the front of this Bharat Ratna, the word Bharat Ratna is mentioned in Devanagari script. When you look at the back of Bharat Ratna, Satyame Javete, truth alone triumphs. That is mentioned in this medallion. This can also be asked in your prelims examination. And in the order of precedence, in the warrant of precedence, 7th position is given to those who are the recipients of Bharat Ratna. These are important facts, can be asked in your prelims examination. Let's look at something else. And this is where a lot of controversy is, a lot of misconception is amongst the students. Article 19 is in the news. Freedom of speech and expression. Clear? In freedom of speech and expression, we have also seen internet ban. For example, in Jammu and Kashmir, just before the special status was revoked for Jammu and Kashmir, there was an internet ban imposed. Even today, high-speed 4G internet is not available to Jammu and Kashmir. Only 2G speed internet is available. Is right to internet a fundamental right? If this is the statement asked in your examination, don't mark it correct. Right to internet is a fundamental right. Kerala High Court says yes. Supreme Court says no opinion on this. So even today, there is no clarity as to whether right to internet is a fundamental right or not. Supreme Court has only said right to freedom of speech and expression is a fundamental right. Right to get this information. How can you get this information? When you have access to the internet. So to get this information, access to internet is important, but right to internet per se is not a fundamental right. Supreme Court has not decided on this matter yet. So there is no clarity, please keep in mind. But when there is an internet ban, which are these laws which allow the state to ban internet in a particular state? Which of the following acts empowers India to suspend internet services to its citizens? Telegraph Act of 1885, yes. Criminal Procedure Code 1973, yes. Public Safety Act, no. National Security Act, no. Again, Public Safety Act is in the news. Former Chief Ministers of Jammu and Kashmir were booked under Public Safety Act. Currently, one former Chief Minister, Mehbooba Mufti, is still under Public Safety Act. National Security Act is also in the news because of Dr. Kafil Khan, who was recently released by Allahabad High Court. So these are almost always in the news. So you can expect a question. Information Technology Act 2000. So 1, 2 and 5. D is the correct answer. It is these three laws which allows the government to suspend internet for its citizens. Let's look at Sushant Singh Rajput case. Sushant Singh Rajput. Did he commit suicide? Was he killed? Was it a case of drug overdose? We don't know. Let law take its own course. Let the courts decide who is guilty. But what we need to understand that initially it was told that it's a matter of suicide. Sushant Singh Rajput committed suicide. For that we need to know there is section 309 of Indian Penal Code. What does this section 309 talk about? It talks about criminalization of attempt to suicide. What does that mean? If I commit suicide and this suicide is successful, I'm dead. But if I commit suicide, this suicide attempt fails, I will be arrested. Because under section 309 of Indian Penal Code, I do not have the right to kill myself. If I attempt to commit suicide, I am a criminal, I will be booked by the police. But on the other hand, there is Mental Health Care Act of 2017. This Mental Health Care Act says that somebody who attempts suicide it would be treated that this particular individual needs care. This particular individual needs affection. This particular individual is under stress. And that is why this individual needs care, attention, protection. He will not be arrested. So there is a conflict. On one hand, we have Section 309 of Indian Penal Code, which says if you attempt suicide, you're a criminal. And on the other hand, we have a Mental Health Care Act 2017, which says if somebody attempts suicide, this person will not be treated as a criminal. We will treat that this person is under stress and he needs care, affection, protection. Both these things conflict with each other. And this is one misconception that aspirants have. Section 309 of Indian Penal Code has not been deleted yet. So Section 309 is still retained on the statute books. That means attempt to suicide can still be treated as a criminal activity. Although there is a Mental Health Care Act, but it conflicts with Section 309 of Indian Penal Code. Section 309 is still not deleted by the Parliament. It is still a valid law. Please be absolutely clear about this. Then something else. And I can safely say this question will definitely be asked in your examination. And I'll tell you how. Convention 182 deals with International Labour Organization's Convention on the worst forms of child labor. Why is this convention in the news? In the history of ILO, in the history of International Labour Organization, this has been the only convention which has been ratified by all the member states. In the history of ILO, if there is a convention which has been ratified by all the member states, that convention is ILO's Convention on the Worst Forms of Child Labor. And very recently, Kingdom of Tonga became the last one to ratify this United Nations, to ratify this ILO convention. So this can be asked in your prelims examination. Let's look at another thing. And I'll give you half a minute to answer this question. Type in your comment and evaluate yourself before UPSC evaluates you. The certificate of essentiality and the certificate of eligibility seen in the news recently is related to which of the following bills? It is related to Surrogacy Regulation Bill 2019. How? Certificate of essentiality, certificate of eligibility. Now there is a surrogacy bill which has been passed by Lok Sabha. It is currently pending in Rajya Sabha. And there is a select committee of Rajya Sabha which is currently examining this surrogacy bill. According to this surrogacy bill, only Indians can opt for surrogacy. Only those Indians who have been, only those couples, Indian couples who have been married for 5 years. If these 5 years, they were not able to produce or reproduce a child, they were not able to conceive, only then they are eligible for surrogacy. So a certificate is to be provided. Certificate of eligibility means you are an Indian because only an Indian can apply for surrogacy. Certificate of essentiality, you will have to prove that it is essential for you to opt for surrogacy. Why essential? Because you were married for 5 years. For 5 years, you could not produce a child. That means now it is essential for you to opt for surrogacy. So this certificate of essentiality, this certificate of eligibility seen in the news is related to Surrogacy Regulation Bill of 2019. Let's look at something else. Anticipatory bail judgment. Let's say, for example, Riya Chakrabarti. If tomorrow she is anticipating arrest, what she can do? She can opt for anticipatory bail. That means in anticipation of arrest, she will apply for bail. There was a landmark judgment given by the Supreme Court on this anticipatory bail. A 5-judge Constitution bench of the Supreme Court had to decide on anticipatory bail. Way back in 1970s, Justice V.R. Krishna Iyer, and Justice P.N. Bhagwati. What they said? They said jail is an exception, bail is the norm. Jail is an exception, bail is the norm. If there is an individual against whom investigation is complete, release this individual on bail. If this accused is not a threat to the society, release him on bail. If this individual is not in a position to tamper with the evidence, release him on bail. If this individual is not a threat to the witnesses of this case, release this individual on bail. Because jail is under exceptional circumstances. Jail is an exception. Bail is the norm. This was said long time ago in 1978 by Justices V.R. Krishna Iyer and Justice P.N. Bhagwati. But the question was, anticipatory bail is valid for how long? If I apply for anticipatory bail today, for how long can this anticipatory bail be valid? Initially, many judgments of the court said anticipatory bail is valid only for a few days, or till the trial is complete, or till the trial is going on. But now a 5-judge bench of the Supreme Court said that if we put a time limit on anticipatory bail, it will violate Article 21, which is right to life and personal liberty. So we cannot impose a time limit on anticipatory bail. That's number one. Number two, Supreme Court said you can apply for anticipatory bail before the crime, after the crime, when the trial is going on, even when the trial is complete, because there is no time limit on the basis of which you can apply for anticipatory bail. This was a landmark judgment given by a 5-judge constitution bench of the Supreme Court. So you can expect a question on anticipatory bail as well. Let's look at something else. Sabarimala review case, again in the news. 2018, a 5-judge constitution bench of the Supreme Court had to decide whether ban on the entry of women of menstruating age. Women of menstruating age in the age group of 10 to 50, they were not allowed entry inside the sacred sanctum sanctorum of the Sabarimala temple. In 2018, Justice Deepak Misra was the Chief Justice of India, and a 5-judge bench of the Supreme Court, by the majority of 4:1, said women of all age groups may pray at Sabarimala. So this age-old practice, this rule, this custom that menstruating age women in the age group of 10 to 50 should not be allowed entry into the sacred sanctum sanctorum of the Sabarimala temple, this rule was declared unconstitutional by a 5-judge bench of the Supreme Court. There was only one judge who dissented. Her name, Justice Indu Malhotra. Why are we discussing this today? Because then, when Supreme Court in 2018 decided to open Sabarimala temple to women of all age groups, then a review case was filed. Dear Supreme Court, please review this Sabarimala verdict. Now the Chief Justice was Justice Ranjan Gogoi. And Justice Ranjan Gogoi did something unprecedented, unheard of. And what he did, he neither accepted this review petition nor rejected this review petition. What he did, he kept the review petition pending. Why pending? Justice Ranjan Gogoi said that there are similar cases which involve similar questions as the questions were raised by petitioners in the Sabarimala case. What are these questions? Justice Ranjan Gogoi said, Muslim women are not allowed entry inside the dargah. Similar case as that of Sabarimala. Number 2, female genital mutilation. FGM. This is something which is practiced by Dawoodi Bohra community. Dawoodi Bohra is a sect in Shia Islam. In their sect, when a girl turns 6 or 7 years of age, her clitoris is either partially or completely removed. Why? because they have a belief that this clitoris is the source of all sins, is an unwanted skin, and that is why it should be either completely or partially removed. Dawoodi Bohra community says it is part of our religious practice, and that is why it should continue. There are petitions which says that female genital mutilation practiced by Dawoodi Bohra community, it should also be disallowed. It should also be declared unconstitutional. Petition number 3. If there is a Parsi woman, if she marries a non-Parsi, she is not allowed entry into the fire temples. That means all the questions raised by petitioners in the Sabarimala case, they are similar to these 3 petitions. So unless and until these 3 petitions are resolved, we will keep the Sabarimala review petition pending. So this Sabarimala review petition, it was neither accepted by the Supreme Court nor rejected by the Supreme Court. It was kept pending. And now a 9-judge Constitution bench of the Supreme Court is looking at all these questions. This is where it becomes even more important for your exam. And you may be asked about essential religious practices doctrine. This essential religious practices doctrine, it was invented by the Supreme Court. This doctrine was invented by the Supreme Court in 1954. The case was Shurur Mutt case. In this case, the Supreme Court took it upon itself to decide whether a particular practice in a religion is essential to a religion or not. If it is essential to a religion, we will not touch this practice. If it is not essential to a religion, we will remove this practice. Ban on menstruating women in the age group of 10 to 50. 5-judge bench of the Supreme Court said this is not essential religious practice. When it is not an essential religious practice, this ban should go. This ban is unconstitutional. And now this 9-judge bench of the Supreme Court is also looking into essential religious practices doctrine, whether judiciary should take upon itself to decide the questions of religion. Because Justice Indu Malhotra said, religion is not a matter of logic. Religion is a matter of faith. What is essential to a religion, what is not essential to a religion, that particular religion should decide. It is not for the courts to enter into the realms of religion. Long story short, Sabarimala review case is in the news. Why? Because in 2018, Supreme Court said women of all age groups may pray at Sabarimala. 2019, Justice Ranjan Gogoi was the Chief Justice of India. Justice Ranjan Gogoi, he did something unprecedented. He neither accepted this review petition nor rejected this review petition. He kept the review petition pending. Till the time, this 9-judge bench of the Supreme Court will look at these larger questions of religion, including essential religious practices. This can be another important question in your prelims examination. Let's look at something else. Minority educational institutions. A petition was filed in the Supreme Court that, dear Supreme Court, we have Article 30, which talks about minorities. And minorities, whether based on language or based on religion. Because there are only 2 grounds on the basis of which minorities are decided in India, either on the grounds of language or on the grounds of religion. The petitioner claimed that there are 9 states in India where Hindus are in a minority. But why should we decide minority pan-India throughout the nation? Why can't we decide minorities based on one particular state? Because there are 9 states in India where Hindus are in a minority. And now Supreme Court has directed the center that you please respond to this public interest litigation, because this PIL is asking for that we should identify minorities at the state level and not at the national level. That means Article 30 is again in the news, and you can expect a question on Article 30. Let's look at something else. UAPA, Unlawful Activities Prevention Act. This was also amended in 2019. Prior to this amendment, only associations could have been declared as terrorist organizations or unlawful organizations. Now, because of this amendment, for the first time now, individuals can also be designated as terrorists. For example, Masood Azhar of Jaish-e-Mohammed, he was declared as a terrorist under Unlawful Activities Prevention Act of 2019. Because prior to this amendment, only associations could have been declared as terrorist organizations or unlawful organizations. Now, because of this amendment, now individuals can also be declared as terrorists. Let's look at the question. The Act empowers the central government to designate an individual a terrorist if he is found committing, preparing for, promoting, or is otherwise involved in an act of terror. Even if you are promoting terrorism, even if through your speeches, through your writings, through your articles, you are promoting the ideology of terrorism, even then you can be declared as a terrorist. Statement 1 is correct. Statement 2, the government is not required to give an individual an opportunity to be heard before such a designation. No opportunity is provided. First, you will be declared as a terrorist. Then you will be given an opportunity to decide to defend yourself. That means before designating you as a terrorist, you will not be heard. If the central government believes that you are a terrorist, you will be designated as a terrorist. Even this statement is correct. Statement 3, you will have to look at very carefully. Statement 3 says an investigating officer has to take prior permission of the Director General of Police of a state for conducting raids, seizing properties that are suspected to be linked to terrorist activities. This statement is correct, also incorrect. Correct in the sense, if an investigating officer of a state is conducting this investigation, you have to seek the permission of Director General of Police of that state. Correct. But if this investigation is conducted by NIA, if this investigation is conducted by National Investigation Agency, then no permission of the DGP of that state is required. No permission of DGP of that state is required. But this officer has to take the permission of the Director General of National Investigation Agency. Statement 1 is correct. Statement 2 is correct. That means 1 and 2, B is the correct answer. 3 is not correct because if this investigation is done by NIA, then the officer of the NIA, he or she need not take the permission of the Director General of Police of that state. It's not required. But he or she will have to take the permission of the Director General of NIA to conduct investigation, to seize the property, all these things. Statement 3 is incorrect. Let's look at something else. Part 4 of the Constitution, Directive Principles of State Policy, and it was in the news because of Special Marriages Act and also because of Uniform Civil Code. Why Special Marriages Act? Let's look at this slide. September 3, 2020. There is a plea in the Supreme Court to strike down certain parts of Special Marriage Act. This Special Marriage Act was passed by the Parliament in 1954, and it is one principal law which governs inter-religious marriages in India. Because if you look at marriage, divorce, adoption, inheritance, these are what we call personal affairs or personal laws, and almost all the religions are governed differently. Almost all the religious communities are governed differently according to their personal laws. So when it comes to marriage, divorce, inheritance, adoptions, different religious communities are governed by their own personal laws. But if there is one secular law for marriage, one secular law for divorce, that law is Special Marriage Act 1954. But even this law is in news because there are some problems with this law. What are the problems? Number one, this act stipulates, let's say for example, there is a boy from Delhi and there is a girl from Karnataka. They want to marry. They can register their marriage only in either Delhi or Karnataka. That means if you want to register your marriage, you should be a permanent resident of that state where you want to register your marriage. So this Delhi boy can register the marriage in Delhi or in Karnataka where the girl is a permanent resident. But now if the families of boy and the girl, they're against this marriage, what is the only option available to this couple? Run away, elope, and then they come to Punjab. Can they register their marriage in Punjab? Yes as well as no. Yes in the sense that when they apply for marriage in Punjab, the district court in that state in Punjab will have to inform the district court in Delhi or district court in Karnataka that someone from your state is applying for marriage in Punjab. Do you know what this is? This is like an invitation given to the family members. Please book your tickets because your son or your daughter has done unthinkable. They've decided to marry in a different state. So come and block this marriage. So this is something which some people say should not have been part of Special Marriage Act. And on top of that, there is a notice period. If you want to marry under personal laws, there is no notice period involved. You can decide today and get your marriage done. But if you want to marry under Special Marriage Act, there is a notice period of 1 month. And in this 1 month, invitations. In this 1 month, we are inviting, if anybody has any problem with this marriage, please come and block this marriage. This notice period also is another problem. And then, if a Hindu, which includes Sikhs, Jains, Buddhists, if a Hindu girl marries a non-Hindu, or if a Hindu boy marries a non-Hindu, he or she cannot inherit ancestral property. These are some important provisions under Special Marriage Act, can be asked in your prelims examination because it has been in the news. Let's look at something else. A landmark judgment given by the Supreme Court. The year was 2020. The Supreme Court held that daughters will have equal co-parcenary rights in Hindu undivided family properties, irrespective of whether the father was alive or not, on 9th of September 2005, when the amendment came into force. What is this question? Let's say, for example, co-parcenary. Who is a co-parcenary? Joint property holdings. Let's say, for example, here is a man. He becomes a co-parcenary in a Hindu undivided family. He can inherit property from his father, from his grandfather, from his great-grandfather. That means till 3 generations he can inherit the property. But who can inherit this property? Only the sons, grandsons, and great-grandsons can inherit this ancestral property. Girls, women could not have inherited this ancestral property. That was the logic, that was the law. But then this law was changed. Hindu Succession Act was changed. The year was 2005. It was said no. Even women, even girls, they can inherit this ancestral property. But then the question was, this amendment was done in September 2005. So what happens if September 2005, if the father was alive and if the father died before September 2005? What will happen to that girl if her property is to be now acquired or not? Long story short, we have had this Hindu Succession Act, according to which what happened? Prior to Hindu Succession Act amendment in 2005, only the male members of a Hindu undivided family could inherit this ancestral property. This act was changed in 2005. Because of the change of this act, now even girls can inherit this ancestral property. But this amendment came into force in 2005. What if the father of this girl has died prior to 2005? Now, this was the dispute, this was the controversy that was to be resolved by the Supreme Court. Why? Because there were two judgments. In 2015, Prakash versus Fulavati, a two-judge bench Supreme Court said, if the father has died prior to 9 September 2005, then you won't inherit this property. But another judgment said in 2018, no matter whether the father has died before this amendment or after this amendment, the girl, the woman can still inherit the property. And now this dispute has been resolved by the Supreme Court. 2020 judgment, Supreme Court said, doesn't matter. When the father of this woman or this girl child has died, she will still inherit the property in the same manner as the male members inherit this ancestral property. So again, this landmark judgment is in the news. You can expect a question on this judgment. Let's look at one previous year question, 2018. Which one of the following reflects the nicest, appropriate relationship between law and liberty? And the answer is, if there are no laws, there is no liberty. And this statement is given by John Locke. So these statements become very important in your examination because there is always a precedence. This question, this type of question was asked in 2018. Similarly, we can expect another question on the same format. Let's look at the question. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. This is reflected in the writings of, please write an answer to this question and tell me. I'll check what is the answer that you've written. And this is reflected in the writings of John Stuart Mill. Can be asked in your prelims examination. Let's look at something else. Competition is the most efficient and fair way of distributing resources and rewards in the society. This philosophy denotes what? It denotes liberalism. So liberalism also is in the news very recently because of various Supreme Court rulings, because of various laws passed by the parliament. And this liberalism denotes competition is the only way, the best way to distribute resources amongst the people. Let's look at something else. Which of the following are constitutional bodies? National Commission for Scheduled Castes, it is a constitutional body. National Commission for Women, it is not. National Human Rights Commission, it is a statutory body, it's not a constitutional body. And we saw this year, National Commission for Backward Classes, it was given a constitutional status. National Commission for Minorities, again, it is not a constitutional body, it is only a statutory body. So 1 and 4, A is the correct answer. Let's look at another thing. And this is the writings of Rabindranath Tagore. Patriotism cannot be our final spiritual shelter. My refuge is humanity. And this is something which is reflected in the writings of Rabindranath Tagore. When we have seen lots of discussion and debate on nationalism, on patriotism in TV debates. So this is something that can be asked in your prelims examination as well. Let's look at something else. When we look at civil services examination, primarily prelims based examination, you will have to focus on facts, you will have to focus on concepts. So UPSC is going to judge your factual knowledge, your conceptual clarity, whether you know the facts, whether you are aware about the concepts. That is something that UPSC will judge you in your prelims examination. When we look at your mains examination, here also UPSC will test two things. Whether you can elaborate the same facts and concepts that you've studied for your prelims examination, whether you can analyze the same facts and concepts that you've studied for your prelims examination. That means prelims is about two things, facts and concepts. Mains is about two things also, but analysis of the same facts and concepts that you've studied for prelims, elaboration of the same facts and concepts that you've studied for the prelims examination. When we look at these facts and concepts, this is where you will have to focus on revision. Revision plays a very important role for you to clear this prelims examination. Why? And you have to at least revise 3, 4, 5 times a single topic that you have studied. Because if you have not revised, it is as if you have not prepared for this examination. It is as if you are not ready for the prelims examination, because you tend to forget things as well. So for that, revision plays a very important role. And how can you understand and link whatever you have studied with current affairs? Whatever static topics you discuss for your prelims examinations, try and find out a link between that static topic and the current affairs. And there is surely going to be a link. Finding that link becomes very important if you have to clear the prelims examination, because it's all about current affairs, it's all about newspaper. If you can know how to read a newspaper, if you can understand how to read a newspaper, there is no reason, there is no power on earth that can stop you from clearing this examination. So current affairs plus your static portion, that is all that you need to know. That is all that you need to know to clear this prelims hurdle. And for that, Hindu newspaper, Indian Express newspaper is very important. What we have done here, we have provided you lots and lots of MCQs. You can download that compilation, target prelims compilation. The link is provided in the video description, and you can revise these hundreds of MCQs that we have collected from the past 1 year, revise them, and surely it's going to help you in your prelims examination. We will look at Keshavananda Bharati. Keshavananda Bharati died yesterday, and it was because of Keshavananda Bharati that Supreme Court on 24th of April 1973 gave a judgment, a doctrine called Doctrine of Basic Structure. What Supreme Court said? Supreme Court said, yes, Parliament has the power to amend the Constitution, but Parliament does not have unlimited power to amend the Constitution. Parliament cannot, through the amendment, alter the basic structure of the Constitution. So if Keshavananda Bharati has died, you can expect a question on basic structure. Please understand one thing. This doctrine of basic structure, number one, is not mentioned in the Constitution. Number two, it is a judicial innovation. Number three, the items in basic structure keeps on adding. In 1973, Supreme Court said judicial review is part of the basic structure. Federalism is part of the basic structure. Later on, Supreme Court said secularism is part of the basic structure. Rule of law is part of the basic structure. Free and fair election is part of the basic structure. Supreme Court also said independence of judiciary is also part of the basic structure. But that means whatever is mentioned in this basic structure doctrine, it keeps on expanding. And who has the power to expand this list of basic structure? Only the Supreme Court, only the judiciary. And that is something that you need to know from the doctrine of basic structure. There is something else that has happened in the past 1 year that can be relevant for your prelims examination. And what is that? Under Article 19, you have freedom of speech and expression, but this freedom of speech and expression is not an absolute fundamental right. there are reasonable restrictions that can be imposed. And one such reasonable restriction is contempt of court. And we have witnessed recently, Prashant Bhushan was convicted by the Supreme Court for contempt of court. Why contempt of court? Because through his freedom of speech and expression, he scandalized the judiciary. How did he scandalize the judiciary? Because of his two tweets. In one of his tweets, he tweeted a photograph of Chief Justice of India, Justice S.A. Bobde, who was riding, or the bike was on the stand, Harley Davidson bike was on stand, and he said that Chief Justice of India is riding an expensive motorcycle which belongs to a BJP leader. He is not even wearing a mask. So this amounts to scandalizing the Supreme Court, and that is why he was convicted for contempt of court. There was another tweet that he tweeted, and he said, democracy is continuously being eroded in this country. And when historians will write about this period, they will equally write about former Chief Justices of the Supreme Court. So these statements, although part of your freedom of speech and expression, but they tended to scandalize the Supreme Court. And ultimately, Prashant Bhushan was convicted and ₹1 fine was imposed on Prashant Bhushan. But from the prelims examination, you need to understand one thing. Who can file this contempt of court case? Anybody can file, but you require the permission of Attorney General of India or Solicitor General of India. Without the permission of the Attorney General of India and the Solicitor General of India, no person can file this contempt of court case in the Supreme Court. That's number one. Or Attorney General on his own can file a contempt of court case in the Supreme Court. That means another way of filing this contempt of court case is if Attorney General himself file this case. Third is the court can also act suo motu, on its own, which means one petition was filed in the Supreme Court by a third person that Prashant Bhushan has scandalized the judiciary, and that is why he should be punished for committing contempt of court. But when a third person is filing this complaint, this third person's complaint cannot be taken up by the judiciary because Attorney General of India or Solicitor General of India has to give the permission. Without their permission, no case of contempt of court can be filed in the Supreme Court. Because recently, actress Swara Bhaskar, she also made a statement during the anti-CAA protests. And there was one application, one case filed in the court which said that Swara Bhaskar should also be convicted for contempt of court. But Attorney General of India, he did not give the permission. When he did not give the permission, that means this contempt of court case could not be filed against Swara Bhaskar. That means if tomorrow there is a question, Article 19 is in the news, one reasonable restriction on your freedom of speech and expression is contempt of court. Who can file this contempt of court case in the court? Number one, Attorney General of India can file this case. Number two, Attorney General of India or Solicitor General of India should give the permission to a third person so that this third person can file the contempt of court case in the Supreme Court, or the court may act suo motu, on its own. And that is what happened in Prashant Bhushan case. A third person had filed this case, but when Supreme Court heard this case, there was no permission given by Attorney General, no written permission given by Solicitor General of India. So the Supreme Court converted this case into suo motu, on its own, and ultimately convicted Prashant Bhushan for contempt. That is again something very important for your prelims examination, can be asked in your examination regarding contempt of court. So what have we discussed as of now? We are looking at current affairs part by part. If preamble is in the news, what sort of questions can be asked from the preamble? If union and its territory is in the news, Why is it in the news? And what sort of question can be asked? Similarly, citizenship, similarly, fundamental rights, similarly, directive principles of state policy. And now we are looking at amendment of the Constitution. This chapter, amendment of the Constitution, is in the news because of the death of Keshavananda Bharati, and we know what sort of question can be asked, the doctrine of basic structure. When we look at Article 19, contempt of court case in the news because of Prashant Bhushan, and this is something that can be asked in your prelims examination as well. Let's look at something else. There is another important developments that have taken place in the past 1 year and can be asked in your prelims examination when it comes to Indian polity. What are these questions basically on? Number one, when we look at elections, People's Political Party of Northeast, it became the first political party from Northeast to be given the tag of a national political party. As of now, we have Congress, we have BJP, we have CPI, CPIM, Nationalist Congress Party, we have Bahujan Samajwadi Party, we have Nationalist Congress Party as well, All India Trinamool Congress of Mamata Banerjee as well. But the first political party from Northeast, National People's Party, this became the first party from Northeastern region to be given the status of a national political party. And who has the power to recognize a political party as a national political party or a state political party? That power is given to Election Commission of India. So this is again something which has happened recently, can be asked in your prelims examination. Let's look at something else. And that has got to do with Jammu and Kashmir. How Jammu and Kashmir was reorganized into 2 union territories, and how the special status under Article 370 was diluted or revoked. Please understand one thing. You may be asked about what was the original composition of Article 370. Article 370 originally said only Article 1 and Article 370 shall be applicable to the state of Jammu and Kashmir. So when Jammu and Kashmir acceded to the Union of India, an instrument of accession was signed. And based on this instrument of accession, the Maharaja of Jammu and Kashmir said, we are transferring only 3 subjects to Parliament of India, to the Government of India. These 3 subjects can be asked in your examination. One is defense, external affairs or foreign policy, and number 3 is communication. When Article 370 was incorporated into the Constitution, the title of this Article 370 was temporary provision. And under this Article 370, power of the Parliament to make laws for the state of Jammu and Kashmir was restricted to which of the following subjects? And those 3 subjects are number 1, defense, number 2, external affairs or foreign policy, and number 3, communication. Please remember these were the only 3 subjects. But can other provisions of Indian Constitution, apart from these 3, can other provisions of Indian Constitution apply to the state of Jammu and Kashmir? Yes. For that, what was the procedure? President had to issue an order, and through this presidential order, any other provision of Indian Constitution could be applicable to the state of Jammu and Kashmir. But here, the permission of the government of Jammu and Kashmir was necessary. That means without the concurrence, without the permission of the government of Jammu and Kashmir, no other provision of Indian Constitution could be made applicable to the state of Jammu and Kashmir. But then Jammu and Kashmir was placed under president's rule because government there could not survive. There was PDP, BJP government in power. BJP withdrew support to the PDP government. The government fell, and ultimately the state was placed under president's rule. When the state is placed under president's rule, who acts as the government of Jammu and Kashmir? The governor of Jammu and Kashmir. And when the state is placed under president's rule, this is where one important thing, Parliament becomes the legislative assembly of that state. That means when a particular state is placed under president's rule, who becomes the executive? Who becomes the legislature? Executive, the governor, who is acting under the directions of the president. Who acts as the legislative assembly of that state? The parliament. Because when president's rule is imposed in a state, the parliament becomes the legislative assembly of that state. And now what happened? All the provisions of Indian Constitution were made applicable to the state of Jammu and Kashmir. Because the governor of Jammu and Kashmir, which is the government of Jammu and Kashmir, gave the permission. And ultimately what happened? One by one, all provisions of Indian Constitution became applicable to the state of Jammu and Kashmir. That's one thing that you need to understand. And when we are discussing this, we need to also discuss three emergency provisions. Which are these three emergency provisions? Number one, we have Article 352, which talks about national emergency. We have Article 356, which talks about president's rule. We have Article 360, which talks about financial emergency. And in the times of COVID-19, financial emergency also plays a very important role, and you can expect a question on financial emergency as well. But very briefly, let's recap Article 352, 356 and Article 360. What is Article 352? Article 352 says if the president is satisfied. But what can satisfy the president? If there is a war, if there is an external aggression, if there is an armed rebellion. We'll have to focus only on facts for prelims examination. If the president is satisfied because there is a war or there is an external aggression or there is an armed rebellion, what the president can do? He can proclaim national emergency under Article 352. Important detail regarding national emergency, important for your prelims. It's not that war should break out or external aggression should have started or armed rebellion has begun, only then president can proclaim national emergency? No. Even in anticipation of war, even in anticipation of external aggression, even in anticipation of armed rebellion, president can proclaim national emergency under Article 352. Very important statement. Number two, what is the validity of this national emergency? Very important for your exam. When the president proclaims national emergency, within 1 month of this national emergency proclamation, both Lok Sabha as well as Rajya Sabha, they have to approve this national emergency within 1 month, and that too by special majority. Only facts, very important for prelims. Definitely expect one question from these emergency provisions. Under Article 352, if the president is satisfied because of war or external aggression or armed rebellion, when national emergency is imposed on the grounds of war or external aggression, it is what we call external emergency. And when national emergency is imposed on the grounds of armed rebellion, we call it internal emergency. But what is the validity of this emergency? Once it is proclaimed by the president, this national emergency has to be approved by both houses of the Indian Parliament, that too by special majority. And once it is approved, this national emergency will continue for 6 months. Can it continue beyond a period of 6 months? Yes. Can it continue beyond a period of 6 months? Yes. What is the maximum upper limit of national emergency? This can be asked in your examination. But there is no upper limit. Why? Because we do not know for how long war will continue. We do not know for how long external aggression will continue, armed rebellion will continue. That means there is no upper limit. Very important statement. There is no upper limit on national emergency. National emergency, once imposed, can continue for 6 months, then another for 6 months, 6 months, continue. There is no upper limit. National emergency, no upper limit. That's something very important for your prelims examination. But what happens because of this national emergency? When national emergency is imposed on the grounds of war or external aggression, Article 19 is automatically suspended. Article 19 is in the news. Freedom of speech and expression. Article 19 is in the news because of Jammu and Kashmir, because of contempt of court case. What happens in national emergency is when national emergency is imposed on the grounds of war or external aggression, Article 19 is automatically suspended. But very interesting thing here is when national emergency is imposed on the grounds of armed rebellion, Article 19 is not automatically suspended. Then President has to issue an order under Article 359 and suspend Article 19. And one by one, all fundamental rights can be suspended when President issues an order under Article 359, but there are two fundamental rights which will not be suspended at all. And these two fundamental rights are Article 20 and 21. That means even if national emergency is imposed, Article 19 will also be suspended. One by one, under Article 359, all fundamental rights can be suspended by the President. But there are two fundamental rights which cannot be suspended. And these two fundamental rights are Article 20 and Article 21. Under no circumstance can these two fundamental rights be suspended even during national emergency. But one interesting thing is, when can national emergency be revoked? National emergency can be revoked at any point in time by the President. At any point in time by the President, but President cannot act on his own. President has to abide by the advice tendered by Prime Minister and his Council of Ministers, by his cabinet. That means President can at any point in time, on the advice of the cabinet, revoke national emergency. But a special power has been given to Lok Sabha. And that power is under Article 352, Clause 8. A special power is given to Lok Sabha that if Lok Sabha MPs, they write to the Speaker of Lok Sabha, if Lok Sabha is in session. If Lok Sabha is not in session, these Lok Sabha MPs can write to the President that, dear President, please convene a special sitting of Lok Sabha. We want to discuss national emergency and we want national emergency to be revoked. If a special sitting is called by the President, then under Article 352, Clause 8, if a resolution is passed by Lok Sabha, that too by simple majority, then what will happen? It is mandatory on the President to revoke national emergency. That means national emergency revocation, one special power is given to Lok Sabha. This power is not given to Rajya Sabha. Under Article 352, Clause 8, a special sitting of Lok Sabha can be conducted if members of the Lok Sabha write to the Speaker or the President, please convene a special sitting of Lok Sabha, and in that, if a resolution is passed by simple majority, then what will happen? It is mandatory, binding on the President to revoke this national emergency. But we have to discuss President's rule as well. Why President's rule? Because of something that happened in Maharashtra. Because of something what happened in Maharashtra, we have to discuss President's rule as well. And I'll tell you the linkage of President's rule with current affairs. What happened because of President's rule? Under Article 356, if the President is satisfied, what will satisfy the President? That there is breakdown of constitutional machinery. One interesting thing for your prelims, this phrase, breakdown of constitutional machinery, is not defined in the constitution. But if the president is satisfied, what will satisfy the president? Governor's report. If the governor's report tells the president that there is breakdown of constitutional machinery, what the president will do? President will impose president's rule in that state. And the first casualty of that president's rule is that Council of Ministers is dismissed. What president will say? The state executive is dismissed. What president will say? That this state legislature, which is no longer present now, it has been kept under suspended animation. Parliament will start making laws for that respective state. That means the complete distribution of powers, which is an important feature of a federal constitution such as India. This complete distribution of powers is suspended, and then what happens? For that state, it is as if we are a unitary constitution. We have a unitary constitution. But when president, on the basis of the report of the governor, says that there is breakdown of constitutional machinery, president's rule can be imposed in that state. One important thing for your upcoming prelims, this governor's report is not important at all. Even without a governor's report, president's rule can be imposed in a state. Because Article 356 says, the president, if he is satisfied on the report of the governor or even otherwise. That means even without governor's report, president can impose president's rule. That is what happened in 1990s when M. Karunanidhi's government was dismissed by the president. President's rule was imposed in Tamil Nadu even without a governor's report. So even without a governor's report, president's rule can be imposed in a state. And then interesting thing is, how can this president's rule be revoked? At any point in time, it can be revoked. But president's rule is recommended by the cabinet. President's rule should be revoked also on the recommendations of the cabinet. Then what happens when we link it with current affairs? Maharashtra. Elections were announced, and in these elections, no political party was in a position to form the government on its own. The governor asked BJP, can you form the government? BJP said, we don't have the numbers. The governor asked Shiv Sena, can you form the government? Shiv Sena said, we don't have the numbers. The governor then asked the NCP, can you form the government? NCP sought time but couldn't form the government. And then president's rule was imposed in Maharashtra. But as soon as it became clear that Uddhav Thackeray would become the chief minister of Maharashtra, because Shiv Sena, Congress and NCP, they have decided to come together. In the middle of the night, at around 5:45 in the morning, president's rule was revoked in Maharashtra. And this is where linkage of current affairs is important. No cabinet meeting was conducted. Even without the meeting of a cabinet, president's rule was revoked in Maharashtra. How is that possible? Because of the transaction of business rule 1961. This is very important for your upcoming exam, and that is what we call an extraordinary power that president and the prime minister can use. That means prime minister can recommend to the president, please revoke president's rule without the advice from the cabinet, without a cabinet meeting, using an extraordinary power under 1961 rules. And it is because of this that president's rule was revoked in Maharashtra, even without a cabinet meeting recommending the revocation of president's rule in Maharashtra. That's the link of current affairs because of president's rule, because of Maharashtra, and this is something that can be asked in your prelims examination. Now, the last emergency provision that we have to discuss is financial emergency. Financial emergency is in the news because of COVID-19. Unemployment is at its peak in India. Some reports say unemployment is at a 46-year high in India. Look at the GDP numbers. It has fallen below minus 23%. It is one of the worst performing economies amongst the G20 nations. But be that as it may, that's part of the economics. My economics faculty would discuss all those details with you. But the point is, during COVID-19, there are many constitutional functionaries who have decided to forego their salaries, who have decided to reduce their salaries voluntarily. For example, president, ministers, election commission. Otherwise, in normal circumstances, this could not have been possible. This could have been possible only if financial emergency was imposed in India. And what is this financial emergency? Article 360 says, if the president is satisfied. And what can satisfy the president? If the financial stability or if the credit of India is under threat. What the president can do? He can impose financial emergency. But there is one interesting thing that you will have to understand here. When national emergency is imposed, it can continue for 6 months. It can be renewed again for 6 months. It can be renewed again for 6 months. Is there an upper limit to the number of years national emergency can continue in India? No, there is no upper limit. National emergency, over. President's rule, there is a limit. The maximum constitutional validity of a president's rule is 3 years. Beyond 3 years, president's rule cannot continue in any state in India. But when we look at financial emergency once imposed by the president, it can continue forever and ever unless and until president revokes it. That means there is no upper limit on national emergency, but it has to be imposed every 6 months. That's what we call periodic parliamentary control. Every 6 months, Parliament should give its approval. President's rule, maximum constitutional validity, 3 years. But when we look at financial emergency, once it is imposed by the president, it can continue forever and ever unless and until president revokes it. That's number one. Number two comparison. When national emergency is imposed by the president, it has to be approved by both houses of the parliament, but within 1 month. And that too by special majority. That means national emergency imposed by the president has to be approved by both houses of the parliament by special majority, that too within 1 month. But president's rule has to be approved by both houses of the parliament within 2 months. And that too by simple majority. Similarly, financial emergency has to be approved by both houses of the Indian Parliament, that too within 2 months, and that too by simple majority. So this comparison becomes very, very important. So you can definitely expect a question either on national emergency. Why? Because some people say in Jammu and Kashmir, internet has been suspended. CRPC 144 was imposed without national emergency. How is that possible? President's rule, Article 356 was in the news, again because of Jammu and Kashmir, but most importantly because of Maharashtra. Because without convening a cabinet meeting, President's rule was revoked from Maharashtra. And financial emergency is in the news because of COVID-19 pandemic. That means despite the fact that COVID-19 has had a massive impact on our lives, financial emergency has not been imposed in India yet, and in all likelihood, it will never be imposed in this country. Financial emergency has never been imposed in this country. This again can be an important statement for your prelims examination. So that is it that we had to cover in today's session. Today's session was primarily about 5 or 6 things. 1. Preamble, citizenship, union and its territory, fundamental rights, directive principles of state policy, amendment of the constitution, the doctrine of basic structure, and the emergency provisions. When we meet tomorrow 7:30 p.m., we will subscribe to our channel and share the links of these live lectures with your friends and fellow aspirants. That is it from us today. We'll meet again tomorrow 7:30 p.m. Till then, have a great time and thank you for being with us. Bye-bye.